ठीक है, जिसको motion. The matter has been amicably settled between the parties.
My lord,
Yes, my lord, there is a. I will come with the petition, my lord. It is a, both the parties, they want to part their ways by way of a mutual divorce, my lord.
Then go to the lower court and have it.
Yes, my lord, we have approached, but there is a little concept in the mind of the wife that when I initiated it, if I now depose before the court that my this one case filing of this case was based on false information that will distribute. That's why they wanted to.
See, list call.
my lord, may I be permitted to mention two revisional applications? Both happens to be the counterblast of the other FIR. Now both have decided to settle the dispute and grievances outside the court. So my lord,
Who is for the state?
yet not admitted, my lord. It is to be listed. It was supposed to be listed today, but it wasn't, my lord. My lords,
Lordship, may I be permitted, Lordship?
notice served to both the ends, my lord. Step up.
Lordship, FMET, MB, Lordship, appeal matters, Lordship.
Affirmative. You know?
Lordship, may I
Be
permitted
put
to mention a matter?
My lord, may I be permitted, my lord? My lord, this is in motion stage, my lord. The petitioners are enjoying an interim order already. So, my lord, kindly, if this comes on the list, we might.
You are for the
I'm for the de facto complainant, my lord.
de facto complainant.
Complainant, my lord.
Who is for the complainant? Who is the revisionist? Petitioner.
My lord, the petitioners are mentioned here. It's in a motion stage, my lord.
You give a notice to the learned advocate for the petitioner and then mention.
May I permitted to
My
mention a
lord,
matter?
we have served a notice, my lord, via email.
Where is the copy of the notice?
My lord, I do not possess the copy right now.
Get
my
the copy and then mention tomorrow.
It's a section 5 application of a second appeal, Lordship. The affidavit to service has already been affected.
Give a notice to the other side and then mention.
Lordship, may I permit to mention 3 motor accident claim matter for the inclusion in the list?
You are for the
I'm for the claimants.
claimants.
Yes.
Who is for the insurance company?
3 different companies are there.
Give a notice then.
I already served the notice. Because is ready, and also there is a. On the 3 matters are related to the only Manu Tribunal did not comply the 171 of MB Act.
No?
Only from the interest ground.
My lord, may I be permitted to mention, my lord, this matter is related to quashing of FIR, my lord, and the petitioner filed an application. My lord, they obtained the stay order and there was direction upon the petitioner to serve notice upon the opposite party. I have communicated with the petitioner, my lord. I sought for the copy of the application, but they are not providing till date, my lord.
You are for?
I am for the de facto complainant, my lord. There was a direction to serve a copy upon us, my lord, but in spite of repeated reminder, they are not serving, my lord, because they have obtained the stay order and they are sitting tight over this.
Give notice to the other side and then mention.
My lord, even that is also not possible, my lord.
Let them refuse and then you mention.
My lord.
Let the notice be refused by them, I list
If
it.
my lord, if it's under to
No.
be mentioned, my lord, then
Give a notice to the other side, learned advocate, and then mention.
my lord.
Lordship, may I permit?
This is FMET appeal matters. MECT.
You are for?
Appellant. Appellant. Already paper.
Appellant insurance company?
No, yeah, claimant.
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 What is the stage?
The hearing stage. Paper book also ready. I have already handed the paper book to the respondent also.
Lordship, may I permitted to mention a matter? It's a FMET motor vehicle matter. Notice has also been served and paper book is ready. It's for the hearing.
Paper book ready?
Paper book is ready. Lordship.
No?
FMET MD matters, my lord, for the hearing.
What is the stage? You are for the wait,
For the claimant.
claimant. What is the stage of that?
The all matters for the hearing, my lord.
Notice served, paper books
Sir, paper books are ready.
ready?
Ready.
Yes. देखिए. Yeah.
Number 1.
আসুন কি দেবেন্দ্র বাবু আসেনি এখনো? রাখবো বলে কেউ আসেন? দ্বিতীয় নম্বরটা কি? দুজন তো অ্যাসাইন হয়েছে, দুজন তো এখানে আছে। তো সেই দুজনকে ব্যাক সেটেলমেন্টটা কি? আপনি কি? আপনি এখানকার, আপনি থাকবেন? This revisional application is directed against the judgment and order dated 31st January 2024, passed by London Additional Sessions Judge Tufanganj, Kuch Bihar, in connection with criminal revision number 8 of 2023, affirming the order dated 28th June 2023, passed by Learned Judicial Magistrate Tufanganj, Kuch Bihar, in miss case number 92 of 2022. Upon none appears on behalf of the petitioner. Upon going through the previous orders, it is found that the petitioner did not appear since 5th November 2024. In the aforesaid backdrop, the revisional application is taken up for consideration on merits.
My senior is standing on 6 report.
Yes, Gunam?
The opposite backdrop, listening speaking of conversation on merits.
Merits. Yes,
Senior is present in the bench. He's arguing on the can make a short pass to the bench.
what points you have to make, you make. Otherwise, dispose of this. This cannot go on. You are taking time, neither you have issued any notice, you are not appearing. Why are you keeping it pending for so long? Twice this matter was called on in this last 2 circuits. See? Ask your senior to come, or otherwise I will dispose of today only. 10 minutes. 10 minutes for.
Your Lordship, we are to govern certain documents. We have to file.
As per the prayer.
Bring some documents for verification by an external document which are not finished. And we have to file certified copies also. Kindly,
Certified copy of what?
kindly, next week.
My lord, certain annexures in the petitions are not complete.
What are
However,
these
we have been
annexures?
waiting for the
What are
docu-
the annexures?
My lord, there is like a list of annexures that we have been waiting for, and we have also applied for the certificate copy for the same. My lord, if my lord kindly takes the matter on next week, we will be well prepared with the petition, my lord.
What is this application? What is this application? 406.
No, my lord, regarding the same, it's a criminal revision and regarding the list of annexes, we need to take some instructions from our senior as well. This is what we have been instructed, my lord. If
What is the order impugned?
my lord, right now I'm not very well versed with it, my lord.
Let me see.
Let's see.
What is this case? Why haven't you taken steps since May?
My lord, we have been trying to procure those certain documents, but we are being unable to get the documents, my lord.
Which documents?
My lord, I'm not very well versed with it, but there is a series of documents, there's a list of documents that we need to also annex to the petition, my lord.
Tell me, what are those documents?
My lord, I need to see instructions regarding the same from my senior.
May 2024. You are still to get hold of the documents to annex.
We have been looking out for it, my lord, and we are being unable to get those few certain documents. It's regarding the land itself, my lord. If I'm not mistaken, my lord, but it's most probably the blueprint of the certain areas of the land. Uh, However, I would not want to make any constructive statement without taking any instructions, my lord. If my lords could just keep it on next week, my lord, we will come with the petition completely ready with all the annexed documents, my lord.
Go back to the trial court.
My lord, kindly then, my lord, praying for Passover, my lord. Let the senior come and
Who is the senior?
my lord, Mr. Navankar Paul. My lord, he's on legs before the fourth one, my lord, division bench.
On the fear of learned advocate for the petitioner is this matter next week, Monday. 27.
Grateful, my lord. My lord, same, number 3 is same.
Same hits? Like, आगे रिकॉर्ड देखिए आगे रिकॉर्ड There are two complaints.
Yes, my lord.
Same 27th.
Passover time to pay the person. That is.
Next part. नहीं तो नहीं.
Number 4.
Five, 224. Ashok. This revisional application is directed against order dated 5th February 2024 in connection with petition PTN short form /R/number 77/24 dated 5th February 2024 under section 144 within bracket 2 of the CRPC. None appears on behalf of the petitioner. Para. It is found from the records that the petitioner also failed to appear on the previous day the matter was taken up, that is on 21st May 2024. CRPC টা দেখেছি। নতুন লিখে দিব problem. Paragraph. As per section 144, 4 of the CRPC, no order under this section shall remain in force for more than 2 months from making thereof. Since the order was passed on 5th February 2024, সিন্সটাকে হ্যাজ করুন তো 5th February 2024 order impugned করুন order impugned was passed on 5th February 2024. Since then 2 months has already elapsed. Accordingly, the order impugned has become infructuous. Hence the revisional application is dismissed as infructuous. All connected applications, again, interim order if any stands vacated. All connected applications if any stands disposed of, urgent certified copy. Five.
There was a direction on serve upon the author by that's the.
In between this period from June till this
would not have been listed, but I was taking endeavors to mention them in this, but the paucity of time the matter to about.
okay. দাঁড়াও। You have section 5 application to be heard out.
Under 227, the limitation is not exactly. I have not preferred any application, but my lord, there is a prayer to condone the delay.
No, there is a CRAN 1 of 2024. 52 days delay.
It was being conducted at Darjeeling, and the petitioner was looked after by the legal aid cell members. They were not well aware of the operations.
This is what is the impugned order?
Not the complaint of the de facto complainant was registered under section 498A and other sections. Subsequently, my lord, the trial court acquitted the accused person, my lord. There were certain findings, my lord, that the court did not appreciate the evidence properly, man. In the same, the appellate court has affirmed the order of the trial.
Acquittal till appellate court affirmed.
But there has been a,
Subodh Tamang. Subodh Tamang is the accused.
no, my lord, actually, he might be the relative of the husband.
Accused.
But he is not the party, but he has received it, my lord, as per the postal receipt. Ningma Dorje Tamang is the husband and father is Sadan Kumar.
State you have not served.
I've served.
Next date. Affidavit of service filed on behalf of the petitioner is taken on record. Petitioner, learned advocate for the petitioner is directed to serve copy of this application in the state is not there. Which page number?
And first annexure is first case. Has been received by the officer.
Yes. Is directed to intimate. No, sir, no. Intimate the next date of hearing of this application to the learned advocate for the state. Now to the office of the assistant public prosecutor. Please. It is assistant public prosecutor's office. Additional public prosecutor's office. 27th. You just intimate the next date. Monday is 27th. Just intimate them, since it is served, just intimate them of the next date. The state's representation is required. Yes.
The petitioner number 1 is the daughter-in-law of the respondent number 2 herein in this petition. And the petitioner numbers 2, 3, and 4 are the maternal relatives of the petitioner number 1. So now, the respondent number 2 is the private respondent who happens to be the de facto complainant of the GR case number 4353 of 2023, my lord. And this petition is under 482 for quashing of the same. So now, one of the respondent number 2 and the petitioner number 1, my lord, they are mother-in-law and daughter-in-law of each other. So that they have some domestic problems, my lord, which aggravated to some extent, that is true, my lord. But then petitioner number 2, 3 and 2 and 3, my lord, they are the maternal relatives who live in a different place altogether. So there is no there is a mention of a incident which took place on 14th of November 2023, and it took place at the shop of the petitioner, and it happened between the petitioner and her husband. The respondent number 2, who happens to be the de facto complainant in this case, she was not there, and it is there written in her complaint itself that she complained on the basis of the phone call received from her son. So basically, my lord, the only cause of action which is here is hearsay or is based on hearsay. So I am praying for quashing of this petition. Quashing of this case, my lord. And this is
Charge framed.
first time it is agreed.
Charge framed.
Charged. No, my lord, charge, I am not aware of the charge not framed to this.
All the FIR of accused has been charge sheeted.
Yes, ma'am. Order dated 2nd of February 2024, ma'am. It is in the internal page number 3 of the certified copy.
Order dated
2nd February 2024. This is the charge sheet being numbered this and this, under section this and this. Cognizance is taken.
plus 24.
Pardon, my lord.
November 24 to November. March is the date fixed for charge.
Charge sheet, your lordship was 18th of February, March 2024 is also there, my lord. Order. I am unable to follow the query of the court. I apologize.
Whether charge has been framed or not. Charge has not been framed. March 25 is the date fixed for framing of charge. Plea and charge.
Yes, ma'am.
Lukiva. No. Mother-in-law is the complainant.
Yes, ma'am. And she was residing in a different residence also. And the complaint is not only against the daughter-in-law, it is against the maternal relative, aunties and brothers, everybody, they are far apart also.
Charge sheet is fine, no?
Just is fine.
Ashwin? This is an application under section 528 of Bharatiya Nagarik Suraksha Sanghita 2023. Corresponding bracket A, corresponding to section 482 of the Code of Criminal Procedure 1973 bracket close. For quashing of proceedings of GR case number 4353 of 2023 under section 341, 323, 354, 379, 506 and 34 of the Indian Penal Code, in short IPC, bracket close. Pending before learned Judicial Magistrate, 4th Court at Siliguri. On a complaint lodged by the mother-in-law against the daughter-in-law and her relatives, alleging of assault, outraging of modesty, theft and threatening. IPC Radindra. IPC. And wrongful restraint. FIR was initiated at Darjeeling PS, being number 945 of 2023, dated 16/11/2023. Para. Also the continue করুন। Being aggrieved by such proceedings, the petitioners have prepared the present revisional application. Yeah. Mr. So and so, learned advocate appearing for the petitioners.
Are the police station we can have Darjeeling?
Pradhannagar. Darjeeling to Pradhannagar. District is Darjeeling. Okay. Pradhannagar. Under district Darjeeling. Mr. So and so, learned advocate appearing for the paragraph petitioner submits that the allegations made in the written complaint are all false and frivolous. And furthermore, the petition number 224 are the maternal relatives of petition number 1 within bracket daughter-in-law. And therefore, they have got no nexus and or connection with the alleged offense, which has, as per the written complaint, has taken place at the shop of the son of the complainant.
It's the name of the petitioner, but the husband of the petitioner.
Son of the complainant, shop of the son of the complainant. He seeks for quashing of the entire proceedings against the petitioners. Para. Upon perusal of the records, it is found that upon complaint being lodged by the mother-in-law, a fire was initiated against the petitioners. On conclusion of investigation, charge sheet has been submitted against the petitioners under section 341, 323, 354, 34 of the IPC. On the basis of prima facie materials. Bearing in mind the aforesaid, this court does not find any merit in the application. Accordingly, the criminal revisional application stands
In 90% of the cases, the charge sheets are filed mechanically.
is dismissed. CRR 9 of 2025 stands dismissed. All connected applications, if any, stands
Please
disposed
explain.
of.
At least the notice may be issued.
Here's the track.
With respect to the other petitioners, madam, who are not, they are present also. How can this?
Next.
My lord, item numbers 8 and 9, my lord, I beg to. My lord, item number 7 and 8.
Seven.
My lord, item number 7 and 8, I beg to appear on behalf of the petitioner, my lord. My lord, my learned friend Miss Acharya is there, my lord, physically before your lordships. My lord, am I audible to your lordships?
Yes, yes.
My lord, this is a quashing of a proceedings, my lord. The charges, my lord, are 316.2 and 316.5 of the BNS. My lord, this corresponds to 406 and 409 of the old Indian Penal Code. The allegation, my lord, is that there is, my lord, non-payment, my lord, of Provident Fund dues. My lord, the petitioner, who is before your lordship, my lord, is one of the directors, my lord, of a company, namely, my lord, Andrew Yule and Company. Now, my lord, Andrew Yule and Company, my lord, owns one Banarha tea estate. Now, my lord, this proceedings, my lord, is due to non-payment, my lord, of Provident funds, my lord, in respect of Banarha tea estate. My lord, if your lordship kindly has, my lord, the FIR, which is, my lord, at this in the certified copy section.
Yes.
Your lordship will, if your lordship has the formal FIR, my lord, formal part of the FIR, kindly see, my lord, the period of occurrence, my lord, marked in the formal FIR. It is May 2023 to September 2024, towards the right top, my lord. Occurrence of offense in the formal FIR, my lord.
Yes, May 23 to September
Yes.
24.
Yes, my lord has seen that. Then my lord will see column 9, the page, my lord. The amount involved is 1,61 lakhs and odd, which is, my lord, the non-payment.
Clause 9.
Clause 9, my lord. I'm deeply obliged. That kindly comes to the next page, my lord, the complaint, which has been treated as the FIR, the written complaint. My lord, it's a cyclo-style complaint, which, my lord, only dots and blanks have been filled up. But nevertheless, my lord, your lordship will find that in the last paragraph of that page, it is recorded the establishment was visited by the undersigned on 14th. My lord has got it, my lord.
Yes, yes.
The last para of the establishment was visited by the undersigned on 14th of November for inspection of the Provident Fund records. On scrutiny of the relevant records, that is wages, salary register, cash book, and monthly returns to be submitted by the employer under para 38.2 of the scheme, it was observed that the employee's share of contribution as detailed in Annexure A were deducted by the employer from the wages of employees, but the employer failed to pay these contributions to the statutory fund. Then, my lord, next page, kindly see the last paragraph of the next page. As the employer of measures Banarha Tea Estate committed misappropriation, last para in the next page, my lord. As the employer of measures Banarha Tea Estate committed misappropriation of the Provident Fund money of the workers, it is requested that a case under section 406, 409 may be registered, treating this as FIR. My lord has seen this, my lord. Now,
Yes.
kindly see, my lord, the next page, my lord, the annexure A that they were referring to, the computation. My lord, there your lordship will get, my lord, that they have computed so that the non-deposit of Provident Fund took place from the period of, my lord, May 2023 to September 2024. On the left-hand side column is the period, my lord, which is serially written, my lord,
Yes.
the month and the year, and that your lordship will find it starts in May 2023 and ends in September 2024. And in the bottom, the total due is written, my lord, which I have also shown from the formal FIR. The total balance due is 1,61 lakhs and odd.
Yeah.
Now, my lord, so far as this amount is concerned, if your lordship will kindly come to, my lord, page 21 of my application. My lord, the entire money which has been complained of in this FIR, my lord, has been paid.
It's
Kindly
21.
have page 21, my lord. Page 21 to, my lord, page 37 are, my lord, the month by month, my lord, receipts, which we have deposited, my lord, of course, subsequently, but we have deposited. Page 21, my lord has seen, my lord. Kindly see, my lord, it is a payment confirmation receipt. And kindly see, my lord, the establishment name. It is Banarha Tea Estate. Kindly see the wage month. The page 21 is May 2023. From there onwards, my lord, page 21 onwards, if your lordship will not turn the pages one after another, my lord will see month by month, my lord, the entire payment has been made up to, my lord, September 2024, my lord, which is the last date, my lord, that they see, the last date is at page 37, the last receipt. So, my lord, the entire Provident Fund dues, which my lord fell due, have been paid, which is a subject matter of this FIR. Now, my lord, the legal issues, my lord, that I was raising, in addition, my lord, to the fact that the entire money has been paid, and my lord, it has been salvaged. My lord, the legal issues, in addition to that, is, my lord, that firstly, the Banarhat Tea Estate, my lord, subject to correction, is not, my lord, the owner of the, my lord, tea garden. Andrew Yule and Company, my lord, is the owner of the tea garden, of which I am a director. I am not an employee of Banarhat Tea Estate. I am, my lord, a director of Andrew Yule and Company. So, my lord knows, my lord, that to my lord, rope in a person in an Indian Penal Code offence or in a BNS offence, my lord, to rope in by way of vicarious liability, my lord, which is alien, my lord, to Penal Code offences or normal criminal law, my lord, the first requirement is the company has to be made an accused. Here in this FIR, my lord has seen, my lord, that Banarhat Tea Estate, which is not a company, it's a tea estate, tea garden, has been made an accused instead of Andrew Yule and Company. So, my lord, the legal issue is that the company has not been made an accused, and I am being sought to be roped into in my capacity as a director of that company, without there being, my lord, any scope of vicarious liability in criminal law. Secondly, my lord, your lordship knows, my lord, that in ESI Corporation versus SK Agarwal, my lord, the Supreme Court has said that the expression employer, my lord, which is used, my lord, in all these beneficial statutes, my lord, namely, my lord, the ESI Act or, my lord, the Provident Fund Act, my lord, in all these places, my lord, the definition of employer is perimeteria, and the Supreme Court says that the company is the employer, not the director. A director of a company cannot be termed as an employer. My lord, I will cite that judgment, my lord, and my lord, your lordship will kindly consider this decision, my lord. My learned friend, my lord, Miss Acharya, will hand up 1998, volume 6, SCC, page 288 before your lordships. Lord, it is a very celebrated judgment, my lord, which has been relied on from time to time by various high courts, including our high court also. If your lordship kindly has this judgment, my lord, once, 1998, 6 SCC, page 288. Para 10 and 11, my lord. Para 10 and 11. My lord, has it, my lord? Para 10 and 11.
Just a minute.
My lord.
Just. Yes, 10, 11.
10, 11. May I read it out for you, lord?
Yes.
Therefore, even if we read the definition of principal employer under the Employee State Insurance Act in explanation 2 to section 405 of the IPC, the directors of the company in the present case would not be covered by the definition of principal employer when the company itself owns the factory and is also the employer of its employees at the head office. Para 11. In any event, in the absence of any express provision in the Indian Penal Code incorporating the definition of principal employer in explanation 2 to section 405, this definition cannot be held to apply to the term employer in explanation 2. As the High Court has observed, the term employer in explanation 2 must be understood as in ordinary parlance. In ordinary parlance, it is the company which is the employer and not its directors, either singly or collectively. I am very much on this, that I am a director of the company. I am not the employer. The company is the employer.
Yes.
The liability to pay Provident Fund, my lord, is not an individual personal liability of any director. My lord, it is a liability of the company, which is a body corporate. My lord, so far as I am concerned, I am merely a director.
Okay.
But nevertheless, my lord, even the company has also used. Now, my lord, this decision, which is, my lord, quite a celebrated one, ESI versus SK, this has been, my lord, relied on in a number of decisions, my lord, by various high courts, my lord. One judgment, my lord, I am just handing up to your lordship, my lord, which is my lord Justice Parthoshaka Datta's judgment, as my lord then was. My lord, it's 2008 SCC Online Calcutta 192, Robin Pal versus State of West Bengal, my lord.
Yes.
My lord will kindly see, my lord, the second paragraph, the second part of the second paragraph, the sentence starting with only one question of law. Para 2, my lord, the second paragraph of para 2.
Yes.
Only one question of law has been raised in this revisional application. This is whether the directors of an establishment can be made answerable to the charge under section 406, 409 IPC. FIRs were lodged against the petitioners under 406, 409 IPC. Commission on deposit of the PUs of the employees at PF authorities. My lord, in paragraph 4, my lord can mark that this judgment, S.K. Agarwal's case, was cited before the Honorable Calcutta High Court, my lord. Then, my lord, the relevant paragraphs are paragraphs 10 and 11. Lord, just to, my lord, save time, paragraph 10, if your lordship has, I am not reading out the entire portion. My lord, I am only placing, my lord, from the middle of paragraph 10, the sentence starting with, having considered a good number of decisions.
Yes.
Having considered a good number of decisions cited by the learned advocates for the parties, I am clearly of the opinion that judgment of the Supreme Court in the case of S.K. Agarwal Supra has given a complete answer to the question, and this court is bound by such decision. It has been held by their lordships in the said decision that in neither of the explanations under section 405 IPC is there found anything to the effect that the directors of the company or an establishment may be prosecuted under 405 IPC for the alleged commission of criminal breach of trust. Then para 11. In both the explanations 1 and 2 to section 405 IPC, it is the person who is the employer and who deducts employee's contribution that is responsible for the commission of the offense. Necessarily, the question is whether the person acting as director can be termed as employer of this establishment, and their lordships in the Supreme Court, in the case of S.K. Agarwal, have categorically stated that the word employer does not include a director.
But your liability will come if you are the responsible person who has deducted, was the person responsible to deduct the Provident Fund.
My lord, your lordship is absolutely right. My lord, but that person, my lord, is a juristic person, namely the company, my lord. It is, my lord, your lordship will visualize, my lord, for whom are, my lord, the Provident Funds deducted. It is deducted for the employees. And the employees are, my lord, all working under, my lord, the company. The company is the, my lord, juristic person who is liable to pay their salary and, my lord, deduct their PF. And it is the company's liability, my lord, to pay before, my lord, the authorities.
Okay.
That is why, my lord, a director, my lord, can never, my lord, pay from its own pocket the Provident Fund dues. Now, my lord, secondly, if your lordship will see one decision of Adoni Cotton Mills of the Honorable Supreme Court, my lord. This is with regard to, this is where, my lord, the Supreme Court says that after the payment is made and secured, there is no point in proceeding against a person. But then at this motion stage, my lord, I will be only requesting your lordship to, my lord, consider my prayer, my lord, to admit my motion, my lord, direct issuance of notice, and, my lord, a stay of the proceedings, my lord, since I have secured the money, my lord. The company has paid everything, my lord. Your lordship knows, my lord, tea industry, my lord, it's a weak industry now, my lord. That is why, my lord, some delay happens. But the entire money has been paid.
Okay.
And, my lord, I sit, my lord, in the office.
Are you pressing for the 1995 judgment right now?
My lord, if your lordship, my lord, is minded, my lord, to consider my prayer for grant of stay, my lord, because I don't want to trouble your lordship with all the judgments at the motion stage, my lord. I understand, my lord, your lordship is, my lord, has a heavy board, my lord.
Okay.
This Adoni, my lord, is a judgment.
1995, which paragraph?
My lord, 1995, my lord, para 3 and 4. There your lordship will find, my lord, that the Supreme Court, upon noticing that the money has been secured, said that there is no point in proceeding further. And this Adoni Cotton Mills, my lord, of the Supreme Court, my lord, has been relied upon also by, again, various judgments of our High Court, my lord, including, my lord, a 2019 judgment of my lord Justice, my lord, Madhumati Mitro in Molhati Tea Industries, my lord. Molhati Tea can also be handed up to your lordships. Adoni was followed and SK Agarwal was also followed.
So this is not the stage to decide on this. So
Absolutely,
far,
my
the other
lord.
two judgments are concerned. Since you say
Lordships.
that the director cannot be FINM since the company is not made a party.
Lordships.
Yes, ठीक है, चलो, thank you.
My lord will kindly consider, my lord, admitting my motion, my lord, and grant me a short interim order, my lord. The entire money has been secured.
Okay. Ashwin, this criminal revisional application has been filed for quashing of the proceedings being GR case number 5770 of 2024, arising out of Bannerhat Police Station case number 325 of 2024, dated 14th November 2024, under sections 316 within bracket 2/316 within bracket 5 of the Bharatiya Nyay Sanhita 2023. Pending before the Chief Judicial Magistrate, Jalpaiguri. Stop. Learned advocate. अच्छा ना एक फैक्ट बोलो ना फेरा करो learned advocate तो केटे दिन on an FIR on a written complaint on a written complaint lodged by enforcement officer regional office Jalpaiguri alleging of non-deposit of the employer's contribution to the statutory fund, which were deducted by the employer from the wages of the employee, the FIR was initiated under sections आगे जेटा बोलना registered as Bannerhat PS case number 325 of 2024 against the petitioner and the Bannerhat Tea Estate. Learned advocate or the petitioner at the outset submits that the alleged period is from May 2023 to September 2024. Stop. The Bannerhat Tea Estate is under the Andre Yule, who has already deposited the entire amount after the initiation of the FIR. And as such, the proceedings for such non-deposit of the share of the employer under the Employees Provident Fund is not sustainable. To buttress his contention, he relies on the decision of Honorable Supreme Court 1995 এটা হবে Adoni Cotton Mills. He also submits that in a proceedings like the instant one, the company is liable to the company is the liable person. The director of the company is not the principal employer to rope in a proceedings as in the instant case. In support of his contention, he relies on the decision of Honorable Supreme Court, Iske Agarwala, 1998, and a decision of this court passed in Robin Pal citation to full diye debo. In light of his aforesaid submissions, he prays for stay of the proceedings. Stop. Upon perusal of the records, it is found that for non-deposit of the contributions to the statutory fund by the employer, a FIR has been registered against Banarghat Tea Estate and Rajinder Singh Mankhu. It is found from Annexure A, page 21 to page 21 to 37, that the payment has been made of the period from May 2023 to September 2024 after the initiation of the proceedings. The company is the Andrew Yule.
My lord, company is Andrew Yule, my lord, which owns, my lord, Banarhat Tea Estate.
Okay.
And also other tea estates.
It is a fact.
I have stated that in para 6.
It is a
Para
fact.
6.
It is a fact that Andrew Yule, which owns Banarghat Tea Estate, has not been named in the FIR. At this stage, it would be relevant to refer to para 10 and 11 quote of S.K. Agarwala Sutra as hereunder. This the aforesaid decision has also been relied on in Robin Pal Sutra by this honorable court. Bearing in mind the aforesaid proposition, this court finds that an arguable case has been made out on behalf of the petitioner. Accordingly, there shall be stay of all further proceedings of প্রথম থেকে নেবেন জিআর কেস নাম্বার পেন্ডিং বানারঘাট এভরিথিং ফর আ পিরিয়ড অফ next circuit 10th February 6 weeks
I'm deeply obliged. Deeply
or until further orders, whichever is earlier. Parties shall be at liberty to pray for extension, modification, and/or vacating of the order upon notice. Next, issue notice upon the state. Let this matter appear before the next available circuit bench. Okay, thank you, sir.
My lord, I'm deeply obliged. My lord, deeply obliged. My lord, next matter is item 8, my lord. That also, my lord, relates to another tea garden owned by Andrew Yule and Company.
Similar?
Similar case, my lord, only the tea garden is different, my lord. Your lordship will find that from the FR. The period is same, May 2023 to September 2024. My lord, this relates to, my lord, Karaballa Tea Estate, my lord, also owned by Andrew Yule and Company. And the payments were made, my lord, page 21, my lord, page 21 to page 38.
22. Page 22 to? No,
Page,
21 to
page
30.
21, my lord. My lord,
20.
kindly ignore page 22 because 22 is a repetition of page 21.
Okay.
21 and 22 are the same pages, my lord. 21, okay. Then 23, my lord. Up to, my lord, page 38. And, my lord, the month by month, my lord, payments. Which were made.
Annexure A লিখে দেবেন, ঠিক আছে? Annexure A. Page number টা দেওয়ার দরকার নেই।
And the case number is also different, my lord. The GR case number and the PS case number will be different.
Same করে দাও, হ্যাঁ? Just এটা change করে দেবেন। কি গার্ডেনটা শুধু change. Thank you.
I'm deeply obliged. I'm deeply obliged. I'm very grateful.
Sir.
This is, I have come before your lordship in the stability school, tolerable exercise of terminology is there. The petitioner number 1 is a senior citizen widow, and the petitioner number 2 is her relative. The husband of the petitioner was a doctor who was posted at Northdale Medical College. He was the head of the Department of Urology Department during the period of 1991 to 2001. Kindly come to page 21 and 22 of my petition. The husband of the petitioner number 1 wanted to buy a plot of land. So he had assigned the senior counsel of Jalpaiguri Bar, Mr. Akram Hossain, to make a searching of that proper land. And a report was submitted by Mr. Akram, stating everything clear. Thereafter, Dr. Kundu, that is the husband of the petitioner number 1, on 26/4/1995 purchased that plot of land. And that land was registered. Kindly come to page 23 and 29 is the deed, registered deed.
23 and 29.
23 to 29 is the registered deed.
This is a land with structure or only land?
And page 30 is my name, Dr. Kundu's name was mutated in the Khatiyan. Page 30. Now, Dr. Kundu died on 17/5/2022 at Calcutta when he was posted at NRS. Page 33. Leaving behind petitioner number 1 and his son who stays at Hyderabad and one daughter who stays at Germany.
Where?
Germany.
Germany.
Yes.
Okay.
Now, after the death, after Dr. Kundu was transferred to Calcutta, the entire family shifted to Kolkata and now resides at Kolkata. So, petitioner number 2, that is the relative of the petitioner number he was assigned to look after that particular plot of land. So one day on 23/7/2024, when the petitioner number 2 went to that land, he found that on the eastern side of the boundary wall, they mentioned he was constructing a boundary
Who?
on
Who?
the mission. On inquiry, the mission revealed that the OP number he was working under the instruction of the OP number 4 and 2. Immediately, the petitioner number 1 was informed by the petitioner number 2 regarding this fact, and the petitioner number 1, that is the widow of Dr. Kundu from Calcutta, made an online complaint with the police station. Kindly come to page 34 to 36.
Yeah.
So she made an online complaint to the police station, and thereafter on 12/9/2024, she filed a suit for declaration and injunction, being titled suit number 515 of 2024. Kindly come to page 37 to 48 is the claim. She filed a suit, and a specific injunction order was given by the junior division, civil judge junior division, restraining the defendants from entering or constructing on the plot of land.
No, the defendants are the opposite party, private opposite parties.
Yes, yes,
All.
yes. No, only I have made the
So-
investigation officer also a party, because I am coming to that fact. Now, after filing of the suit by the petitioner, number 1, the complainant, that is the OP number 2, claiming to be the constitute attorney of one Sri Gautam Basu, she filed a suit against the petitioner number 2. That is title suit number 526 of 20, page number 49 to 62.
No.
Now,
Wait. Gautam Basu.
yes,
Gautam Basu is, what is his status?
he claims that the petitioner, thereafter the wife of the complainant, that is the OP number 2, the OP number 3 claiming to be the constitute attorney of one Sri Gautam Basu, that is the OP number 6, filed a suit being titled suit number 526 of 2024 with regard to the same land. Area is different.
Okay.
And upon motion, the learned court had passed a status quo order. Thereafter, this petitioner number 2, she obtained a information certificate from the land department. This plot of land, whose names are recorded. Now, please come to your lordship, page number 63. That is the information slip issued by the land department. It could be noticed beyond all reasonable doubt that the name of Dr. Anup Kundu and Gautam Basu appeared in plot number 132.
Page number once again.
Page number 63, my lord. Let's see, at the bottom, Dr. Anup Kundu
Yes.
and Gautam Basu. So, if there is any dispute, the dispute is regarding identification of a land, which is a civil dispute in nature.
Okay.
But most interestingly, after filing of these 2 suits, they have filed a complaint against the petitioner number 1, petitioner number 2, petitioner number 3, who happens to be in Hyderabad, and petitioner number 4, who happens to be and her daughter, who happens to be in Jammu. So I have prayed for quashing of the complaint, against which case has been registered by the Bhaktinagar.
Who is the complainant? How the complainant is related to Shormistha?
I beg your pardon.
Complainant is Partho Singh.
Without having any right, because Shormistha, his wife is the constituted attorney. But her husband had filed the complaint. Even he doesn't
Surmisa is
have
the
any-
constituted attorney of Gautam Basu.
Gautam Basu. If the
Now,
complaint-
Gautam Basu, by way of a purchase, he has some portion of land in the property, and this Dr. Kundu has also some.
Yes.
They have, by between them, inter-se parties, there is a civil suit.
Yes.
One is 515, one is
Yes.
526.
Yes.
Now, this Partha Singora has lost the complaint.
Yes. If the complaint has to be filed, it has to be filed by the power of attorney. But the complaint has no locus standi to file that complaint.
Anyway, what is the allegation in the complaint?
Well,
That they were threatened laborers, masons, with diagnosis that the dispute is.
All afterthought. And just to put on pressure, because in my suit, there is a specific injunction application, not to interfere with my possession.
And their suit status quo order is also.
Status quo. So just to put a pressure on that, they subsequently after filing of that civil suit, they have filed this complaint. And a case was registered. So, Your Lordship, I pray for stay of the proceeding.
Okay. State is the only party.
Yes. State and
The state and the private respondents,
the private. Yes.
they have to be served.
Yes. Definitely.
This Ashu? This criminal revisional application has been filed. For quashing of the criminal proceedings being Bhaktinagar Police Station, case number 904 of 2024, dated 4th October 2024. Under sections 329 within bracket 3/324 within bracket 4, 308 within bracket 3/336 within bracket 2/338/376 within bracket 3. এটা দেখে নেবেন 3 মিলিয়ে নেবে না বলে দিচ্ছি দাও /340 within bracket 2/351 within bracket 2/61 within bracket 2 of the Bharatiya Nyaya Sanghita 2023, pending before which court? Pending before Learned Chief Judicial Magistrate, Jalpaiguri.
One small submission also.
Yes.
From page 64 to 66 and 67, 68, both the petition number 1 and 2 prayed for anticipatory bail. And the learned session judge has granted the anticipatory bail, giving his observation that the matter is a civil dispute.
Okay. On a complaint lodged by one Sri Partho Singh Roy within bracket respondent, opposite party number 2, with the allegations of threatening the main agents and laborers at the time of construction of wall over the disputed land in question, comma, a fire was registered against the petitioners and two others. Mr. So-and-so learned advocate appearing for the petitioners submits that the late husband of the petitioner number 1 purchased a plot of land comprised within LR plot number 132 No. If we come to page 25, is it correct or the LR number will be separate?
LR is 30, page 30.
Actually, complaint is
No.
Where is the schedule of Ashwin? Comprised within RS plot number LR बोल ना? LR plot number 132 within bracket part of RS plot number 340 within Mouja Dabgram police station Bhaktinagar within bracket Rajganj bracket close district Jalpaiguri. After the demise of the husband, it came to the knowledge of the petition number 1 that some work of construction of boundary wall was undertaken in the purchased property of her late husband. The petitioner number full stop, the petition number 1 filed a civil suit being titled within bracket declaration suit number 515 of 2024. Narayan Goel, yes, against opposite party number 4, Shotto Narayan Goel, opposite party number 2, Partho Singh Rai, opposite party number 5, Vikas Roy, and others. So, in the said suit, an ad interim order of injunction was passed, and the defendants and their men and agents were restrained from causing interference to the peaceful acts of possession of the plaintiff, and also forbidden from encroaching any portion of the suit property forcibly. This application has been heard out.
Which one?
This temporary injunction application
No.
still pending. No.
Because thereafter we have made this Gautam Basu a party, we have that
No.
has been
Order 1 Rule 10
yes,
application.
subsequently that happened. Because that has to be made, otherwise,
Thereafter, another suit has been filed by opposite party number 6, Sri Gautam Basu, against the petition number 2, being titled suit number 526 of 2024, wherein a order of status quo has been filed by the trial court. Passed by the trial court.
through the petitioner number.
Filed
wife
Gautam
of
Basu
petitioner
through
number.
constituted attorney Srimati Sormistha Singh Rai, opposite party number 3. Subsequent thereto, the present FIR has been lodged by the husband of the constituted attorney, Sri Partho Singh Rai, who has got no locus standi so far as the litigation inter se between the parties are concerned. He also submits that the son of the petitioner, number 1, is a resident of Hyderabad. And who is the daughter?
Ananya Kundu is the daughter.
And the daughter, Ananya Kundu, is a resident of Germany. The contents of the FIR is false and frivolous and cannot be sustained. Stop. The entire dispute is civil in nature. Considering which, anticipatory bail has been granted in favor of petition number 1 and 2 by the learned Sessions Judge Jalpaiguri. Para. He seeks for stay of the proceedings. On going through the documents appended to the application, it is found that the late husband of petition number 1 purchased a plot of land measuring 2 kata 13 chitaps, 30 square feet. Comprised within LR যেটা বললাম, LR plot number. And his name has been recorded in the LR record of rights within bracket annexure P9. There is civil suit pending between the parties. At the instance of petition number 1 as well as opposite party number 6. Such being the position, this court finds that an arguable case has been made out by the petitioners. Accordingly, there shall be stay of all further proceedings in for a period of 6 weeks or until further order. Parties shall be at liberty যেটা থাকে issue notice upon the opposite parties. Learned advocate on record for the petitioner is directed to file affidavit of service on the returnable date. State was. That is the office of the additional public prosecutor. So, list this matter before the next available circuit. এই পাসওয়ার্ডটা একবার ডাকুন কি পাসওয়ার্ডটা লিখুন
Which of the options stand for this?
ইয়েস থ্যাংক ইউ
Password number ID number 1.
অনেকক্ষণ 10 মিনিট পাসওয়ার্ড ছিল কিছু নেই ম্যাম এটাকে শুরু করেছিলাম দিয়ে পাসওয়ার্ড নিয়ে চলে গেল তো একে ডেকে দেবেন তো মিঠুন কখন আসবে এরপরে মিঠুন কখন আসবে ওদেরকে দিয়েছিলাম শুরু করেছিলাম তখনই মাঝে এসে বললো যে পাসওয়ার্ড আসবে তাহলে এটা থাক একটু পাসওয়ার্ড একটু পরে দেবেন তাহলে একবার ডেকে দেবেন
Number 10.
Item 10, my lord, I am praying to appear before your lordship through online mode, my lord. My lord, I am appearing on behalf of the petitioner, my lord. My lord, in this instant case, your lordship, opposite party, wife, my lord, has filed one case against the petitioner under Domestic Violence Act, my lord. And my lord, they do not serve any notice upon the petitioner, my lord. And after getting ex parte order, your lordship get it from page 22 and 23. My lord, they serve ex parte order to my exact proper address, my lord. But if your lordship kindly see, my lord, plain, my lord, in page number, my lord, page 30, there my address is Sri Sujoy Kumar Roy and others, son of Bhanu Kumar Roy, residing at City Center, Ward number 22, Post Office City Center, PS Durgapur, District Paschim Bardhaman, PIN 713216. And my lord, in page 22, my lord, my address is, which is my correct address, my lord, it is Roy Transport Corporation, Sri Sujay Kumar Roy. Actually, my lord, Roy Transport Corporation is owned by my father Bhanu Kumar Roy, son of Sri Bhanu Kumar Roy, of Prakash Bhavan, GT Road, Bhiringi, Durgapur, 713203, District Paschim Bardhaman, phone number such and such, my lord. My lord, as a result, my lord, in this proceeding, I cannot appear before the learned judicial magistrate court, and they obtain an ex parte order in favor of them, my lord. Then we have filed one case.
Why you cannot appear?
My lord, copy, my lord, someone has not served upon me properly, my lord. My lord, it is page number 22, my lord, kindly see. After obtaining ex parte order, they send in my correct address, my lord. It is Roy Transport Corporation, which I have received. But my lord, if your lordship kindly see page 30, my lord, in plain, there my address is residing at City Center, Ward number 22, Post Office City Center, PS Durgapur, District Paschim Bardhaman, PIN 713216. And my lord, if your lordship kindly see server copy, my lord, at page number in page 24, my lord, at bottom, my lord, at the very outset, be noted that the petitioner filed the instant case on 6 December 2022 in the court of the learned CGM Jalpaiguri, where the case was registered and it was transferred to this court for final disposal. After receipt of the case, on transfer, this court issued notice upon the respondent. The notice was not duly served, even though the OP has been appearing in other cases using the same postal address. However, even after execution of all modes of service, summons could not be served, due to which alternative means of service, that is paper publication, was allowed by this court on 8 December 2023. After which a paper publication made on 16 December 2023, but till the respondent failed to appear, as such the case proceeded ex parte against them on 6 February 2024, my lord. My lord, petitioner not received any summon, my lord. And my lord, then appeal before the learned district judges court at Jalpaiguri, my lord. And from this, if your lordship kindly come in my certified copy portion, my lord, one order was passed, but my lord, if your lordship kindly come, order number 10, my lord, learned lawyers for the contesting parties are present. The case is taken up for admission hearing. Had both the sides perused the material on record considered, it appeared that delay in filing the instant criminal appeal has already been condoned by the order dated so and so passed in this case. Office report speaks that the instant appeal is in order and duly stamped. Accordingly, the present criminal appeal is admitted. Stay petition filed on behalf of the applicant is taken up for hearing. Upon hearing both the sides, it appears that purpose of instant criminal appeal shall get fractuated if the impugned order dated 26 February 2024 passed by the learned judicial magistrate First Court Jalpaiguri in Miss Petition number 410 of 2022 is not stayed. At the same time, adequate measures are to be taken so that the respondent wife does not suffer from starvation. Accordingly, impugned order dated 26 February 2024 passed by the learned judicial magistrate First Court Jalpaiguri in Miss Petition number 410 of 2022 is hereby stayed till disposal of the present criminal appeal on condition that the appellant shall go on paying a sum of rupees 11,000 per month to the respondent wife as condition precedent. Let it be made clear that this order granting stay over the impugned order shall stand vacated if the appellant fails to make payment of the above amount to the respondent wife on any occasion, my lord. My lord, then matter was fixed on 17 December 2024, my lord. And that day, my lord, my client unable to appear and through his learned advocate prayed for time, my lord. My lord, and this, my lord, in this case, my lord, opposite party wife also prayed for time, but opposite party wife, which petition was filed for time, my lord, it was allowed, but my petition was not allowed, my lord.
You have made payment.
My lord, I have payment one time, my lord. I have annexed in page 34, my lord. I have paid 15,000, my lord. At page 34, my lord.
Page 34.
Yes, my lord. Annexure P4, my lord. My lord, on behalf of opposite party wife, his learned advocate has received this money from me, my lord.
After passing of the order in the criminal appeal, have you made any payment?
No, my lord.
Then
my lord, I have prayed for time 1 week, my lord. But it has
go back to the
allowed, my lord.
sessions judge. This is an application. Criminal revisional application.
My lord, I am an unemployed person, my lord. It is too much hard for me.
Go back and make your submissions before the learned sessions judge. Your appeal is pending.
My lord, there is a order for giving.
What is your prayer in this application? What is your prayer in the application?
My lord, I am praying for vacate of the order number 11, order dated 17 December 2024.
Ki bolna? This criminal revisional application has been filed for vacating order dated 17th December 2024, passed by learned sessions judge Jalpaiguri in criminal appeal number 14 of 2024. Under section 29 of the Protection of Women from Domestic Violence Act 2005. Mr. So and so learned advocate for the petitioner submits that an order was passed ex parte in respect of a petition filed under section 12 read with section 18, 19, 20, 22 of the Domestic Violence Act 2005 by the learned Judicial Magistrate First Court Jalpaiguri. Stop. Assailing such order passed ex parte by this without proper service of summons. Assailing such order, the petitioner preferred an appeal before the learned sessions judge Jalpaiguri. By order dated 19th November 2024, the order of the Judicial Magistrate First Court Jalpaiguri was stayed stop. However, on the subsequent date, that is 17/12/2024, those steps were taken for extension of the order of stay. But at the time, since nobody appeared, the stay granted earlier by the Sessions Judge Jalpaiguri was vacated. Against such order, the present criminal revisional application, being agreed by such order, the present criminal revisional application has been filed. He seeks for vacating of the order. On going through the impugned order under challenge dated 17th December 2024, it is found that it has been recorded in the order that none appear on behalf of the parties to move their respective applications. And the stay granted earlier on 19 November 2024 was vacated. This court does not find any illegality in the order passed by the learned Sessions Judge Jalpaiguri, and hence does not merit consideration. In view of the in the aforesaid background, the criminal revisional application being CRR 14 of 2025 stands dismissed. Connected applicant into order. Take it.
My lord, item number 11, my lord, I am appearing on behalf of the petitioner, my lord, I am praying for
Not yet called, not yet called, sir. কি বলেছেন ওগুলো?
I'm going to see upon the order dated 28 June 2023, passed by the first one, Judicial Magistrate Provident, whose beer, in this case, on the second none appears on the order of the petitioner. After going through the previous order orders, it was found that the petitioner did not appear since 5th November 2024. In the apostate, therefore, the evaluation of
এইখান থেকে কেটে দাও।
in the apostate.
At the time when the matter was called on, এই কটার সময় ডেকেছিলাম? ওই 11টা হবে না?
Second,
11:15 করবে। Matter was called on at 11:15 AM. The matter was passed over for 10 minutes on the prayer of the learned advocate for the petitioner. Next line again. It is now 12:50 PM. None appears on repeated call on behalf of the petitioner. Stop. It is found from the records that on previous dates since 5th November 2024, the petitioner did not appear. In the aforesaid backdrop, the present revisional application is taken up for consideration on merits. The brief fact of the case is that the mother of the present petitioner filed an application under section 125 within bracket 1 D of the Code of Criminal Procedure, Criminal Procedure Code within bracket hereinafter referred to as the CRPC, bracket close, claiming maintenance at the rate of rupees 12,000 per month for herself, which was registered as Miss Case number 92 of 2022. before the learned judicial magistrate Tufanganj. On consideration of the materials and record. Yes, you have got anything to submit? No, 10 minutes is over. This is the third time. This cannot go on. I'm disposing of it. If you have got anything to submit, submit. Is taken up for consideration. ওই জায়গাটা কেটে দিয়ে ওইটা কেটে দিন। ওই ওপরে যেটা বললাম ওইটা।
Also minor children and a wife to maintain.
আচ্ছা।
And there is already three sons.
মানে যেটা ওই বললাম নন অ্যাপিয়ারেন্স এখন উনি অ্যাপিয়ার করলেন তাহলে ওইটুকু এ করে দাও বা তুমি রেখে দাও আমি কেটে দেবো যে পোর্শনে বাদ দেবো ঠিক আছে Mr. So and so learned advocate for the petitioner submits that the mother has landed property and on the other hand the petitioner has his own family and minor children.
The mother has also have three more children, Lordship, and a daughter.
So the mother has also other children, including a daughter. কি বললাম? Other. Hence, the impugned order passed by the learned sessions judge in criminal revision number 8 of 2023, affirming the order of the judicial magistrate should be, what is your prayer? Set aside? Should be set aside. Upon going through the impugned order of the learned sessions judge under challenge dated, what is the date? 31st January 2024. The date of order তো বলেছিলাম গো।
January 20.
31st বলেছিলাম না ওপরে? 31st January. It is found that the learned sessions judge has taken into consideration the of the fact that the present petitioner has sons and daughters. Sorry, sons and daughters. It is has taken into consideration of the fact that the respondent number 1 has other sons and daughters. It is not in dispute that the petitioner, he works in railways, is an employee under the railways. Which has also been taken into account by the learned sessions judge. In the aforesaid backdrop, this court finds that there is no illegality or infirmity in the order passed by the learned sessions judge. Reasons. Criminal revision application being and so stands dismiss interim order if it's vacated.
Much of it.
Yes. এই মিঠুন বাবু আপনাকে পুরোটাই দেবেন আমি কেটে ঠিক করব কোন জায়গাটা চেঞ্জ নেক্সট
My lord, item 11, my lord, I am praying on behalf of the petitioner, my lord. My lord, I am praying for leave to file appraise, my lord. Because, my lord, in annexure P1, my lord, has not been annexed with the petition, my lord.
P1, what is P1?
P1 is, my lord, FIR, my lord.
Oh, FIR has not been annexed.
My lord, I am praying for leave to withdraw and file appraise, my lord.
দেখি Oh. This criminal revisional application has been filed for quashing of the proceedings arising out of Rajganj Police Station case number 536 of 2022, dated 20th September 2022. Mr. So and so, learned advocate appearing through virtual mode, submits that
My lord, annexure P1 in para number 3, my lord. And annexure P2, my lord, para number 6, my lord. Annexure P2 has become annexure 1, P1, my lord. It is fault.
there is certain mistakes, inadvertent mistakes in marking of the annexures, namely annexure P1. He seeks to withdraw the revisional application with liberty to file afresh. In view of such submissions, the present revisional application being CRR 15 of 2025 stands dismissed as withdrawn with liberty to file afresh.
Great.
None appears on behalf of the petitioner. List this matter on কবে দেবো? List this matter on বলুন কোথায় গেল? 27 না 28 দিন 28. তিনটে দিন Next.
You're not happy. That is single council is also a matter for photo number one. Not part of the.
Yes.
Well, it's not to stay off order, Proceed. On 9th of December 2024, non-billable warrant of arrest for issued against the petitioner.
No year of birth. Yeah. What is his name?
Amjad.
Absent filing time period.
It's a resident of Rajasthan, Russia. So he was suffering from some diseases.
He
For
should
that
have-
reason he could not appear on the 4 consecutive dates. For that reason, this non-billable warrant of arrest has been issued. Also,
Amjad bailed.
kindly stay the warrant of arrest for a limited period. In the meantime, you will surrender and pay for it.
No. Go and surrender.
So, I will surrender for kindly for a limited period for 1 week.
Period until further and shall not immediate. Even if you fail to appear the trial, the judgment shall be at liberty to cancel. The bail has no. The bail is conditioned bail. How can this be stayed?
No, should that be further company?
No. This revisional application, a criminal revisional application has been filed against the challenging order dated, order number 49 dated 9th December 2024, issuing warrant of arrest against the petitioner. Mr. So and so learned advocate appearing for the petitioner submits that the petitioner is a resident of Rajasthan. Is a resident of Rajasthan.
Page 13 is the medical document.
Is a resident of Rajasthan and could not appear on the date fixed, due for which reason warrant of arrest has been issued against him. He prays for stay of the execution of such warrant of arrest. He undertakes that the petitioner will surrender in the meantime. By order dated 3rd March 2023, the Honorable Division Bench granted bail to the petitioner. Amjad was also granted. On the condition that the petitioner shall appear before the trial court on every date of hearing until further orders and shall not intimate the witnesses and or tamper and or tamper subject to conditions. In the event the petitioner failed to appear, a condition. On 9/12/2024, the accused person failed to appear and sought for time which has been rejected by the Judge Special Court under the NDPS Act, bracket close, first court, Jalpaiguri, and issued warrant of arrest. Bearing in mind the order of the Honorable Division Bench. This court does not find any infirmity in the order passed by the learned judge special court under NDPS Act. In view of the above, the criminal revisional application being CRR 19 of 2025 stands dismissed. Interim orders. What is this matter? No answer. 498. What is the order impugned? Which order has been challenged? Order. Not to.
Number 15.
15.
After the petition. This revision application appearing for the first time, and it has been challenged, has been favored by challenging the final order and judgment of the maintenance passed by the Honorable Learned Judicial Magistrate First Court Calcutta against the final order, judgment and order of maintenance. Lordship, as this matter is appearing for the first time, I will grant the liberty to serve on the opposite party and then came back. So come back so that this matter can be heard.
What is the ground?
Lordship, the maintenance allowed is the prayer is the setting aside of this judgment and also the reduction of the maintenance. One of maintenance.
You are senior manager of a bank. What is your salary?
Number 31, connection E3. Salary is 30, net salary is 38,780.
Rest amount? Rest?
Gross amount got 87,000.
Then the other rest amount, in which account this is going? No, no, the gross salary is 1,26,000. What 87? Net of that is the deductions. So what is the deduction? Home loan. This is your asset. You are paying a home loan. Now it is a festival advance. You are paying this amount.
Interim order was granted, that time I was consciously paying that actually. Even I am today, I am paying that amount.
Any execution case filed? No.
For 1 month, that tomorrow the matter will be appeared. I have challenged the execution order. Execution petition for Quashing. For 1 month, they have come before lordship for challenging, for filing even the time period of not, filing of initial application is not executed, they have still come before for 1 month.
So you have filed a revisional application against that also.
The divisional time period has not been elapsed, no, they have come before. But may the matter be fixed tomorrow, tomorrow the both are underpaid.
What is the number of the other revisional application?
26.
Raj- Okay. चलो
लकड़ी रहने से कहाँ आधे आधे किलो एक किलो वही लगा था हाँ वो ठीक है सर तो बैठे के बाद जगह तो है सब करे कुछ छोड़ नहीं yo por ahora cambiamos técnico ये है ना काठ वाला तो हम कलकत्ता में मिले काठ वाला लेकिन यहाँ नहीं है काठ वाला वो पूरी पुलिस ऑफिसर में बच जाए एक बहुत की इधर उतना मतलब ना
এই সুমিতা
আমি ঘুরে চলে এলাম
আমার হচ্ছে আমি তো এই যে বেশি আমি এসেছিলাম তো তোমার ঘরে চল সুপতি এসছে আমি কি
ওই ক্যালেন্ডারটা নিব
আমি
একে পাঠিয়ে দেবো তুই দিয়ে
সই করে নিতে হবে
হ্যাঁ তার জন্য সই করে নিতে হবে
আচ্ছা 100 টাকা ধার্য রেখেছি ঠিক আছে এই মাসে নাম নিয়ে বললাম উপরে তুমি আমি তখন তো তোমার ওখানে এসেছিলাম আমার
ঠিক আছে এটা নিবেন না রাখো হ্যাঁ
এই ছেলের নামটা কি জানো কি রয়েছে
হ্যাঁ এটা রাখো হ্যাঁ
সুজন ফোন দলে করে
না
হ্যাঁ না আমি যাই ওতে আপাতত রয়েছে কোন জায়গায়
আমাদের দিকে নাম
তোমার কম্পিউটার থেকে না না যেটা রেজিস্টার এবারে কম্পিউটার আছে ওই ওখান থেকে কি প্রথমে 54 না? হ্যাঁ হ্যাঁ 54 মানে এইটা প্রথমে সিভিল তো যদি ধরে তাহলে 54ই প্রথম মানে ও হ্যাঁ ওগুলো তো টেস্ট থেকে শুরু হতে 17 থেকে হ্যাঁ সিও কতগুলো আছে আবার হ্যাঁ হুম আমরা দিয়ে করে নিই হ্যাঁ বাস সেকেন্ড
শেষ হয়ে যায় তাহলে তো ধরে নেবে আগে শেষ হয়ে যাবে হ্যাঁ
তিন নম্বরটা অ্যাকচুয়ালি লোকদার কোনটা বুঝলি আমরা কি বলবো The paper will not have to go. We have to
অটোমেটিক ওটা ক্রস করে আবার ওটা টাইপ আবার ওটা বার করতে গিয়ে দেখি যেটা এতটা টাইপ করলাম যে সব হয়ে গেছে আবার বুঝতে টাইপ করলাম ওটা প্রিন্ট করলাম তারপর দেখলাম স্টেপ হয়ে গেল তুমি করো এটা ছাড়া করতে যাও একদম ওটা খেয়ে গেছে এটাই কতদিন হচ্ছে
होगा काम देखें नहीं होगा और थोड़ा पीछे में और थोड़ा देना पड़ेगा अभी नहीं बाद में कल लगा दी कत नंबर से शुरू हो ना 17 देखिए कत 17 as for request for petition let the matter will issue the next
Lordship, item number 17. Lordship, item number 17, for one document. Mr. Vikramaditya Goswami, in court number 2, one document.
The accommodation is going on since October 2024.
One as a last chance.
What last chance? The court records that please do not embarrass this court by seeking adjournment. Court has recorded in order dated 3rd January. The one after the other is seeking adjournment. What is this matter? What is the order impugned and what is the order passed by the tribunal? On the floor of learned advocate for the petition. Solve the procedural. Is this matter on Wednesday? What are you? 26.
The hearing for the first time before my lordship. Service in the matter is complete. And I will explain the facts of the case and then I will take my lordship to the order impugned. What happened was that a person was he enters into a bill. The bill was executed on 18th of November 2010. Now, after the death, he executed the bill in favor of his 3 sons to the exclusion of 3 daughters. Now, after he expired, what happened was that a probate suit was filed. Now, initially, the probate suit in 2014 was filed before the Royal Court. The claim was returned in 2017. It was filed.
Who filed it?
The executor himself has filed.
Executor is one of the son.
No, executor is a different.
Then what happened that during the pendency of the probate proceeding, two of the attesting witness, both the attesting witness, they have already expired. So now, what happened in the suit is that I have to leave certain secondary evidences in order to prove that the will was executed and that is not an original will and not a false will. Now, under these circumstances, at page 40, you will find the ordering king.
Page 40.
4040.
Maybe the further evidence. The evidence was going on.
Evidence was going on.
So what happened? Blood accounts was paid for time to reduce it. Right? Based on the report. Yeah. How many times you have prayed for time?
In detail, paragraph number 5, at page 8, will find the entire detail is there. I straight away take notes to paragraph 6 at page 10.
Yes.
I'm reading the second line. On 30th January 2018 and on 5th February 2018, the case could not be advanced due to unavailability of records from the lower court, which was an administrative lapse. Further, on 6th March 2018, the defendant sought and was granted adjournment, contributing to additional delay. Lastly, on 12/7/2018, the proceeding was stalled as the presiding judge was on leave. So there were different reasons. At occasions, yes, the executor or the plaintiff also has taken time. That is correct. And that is precisely because at page number 6, will find that my mother expired, and at page number 7, will find the two attesting witness of the will died during the pendency of the suit. One died on 17/7/2014, and the second one died on 28/7/2022. So, in the absence of that attesting witnesses, because the primary evidence is not there, some secondary evidence has to be laid. That is the reason why there was a delay.
Evidence. Evidence actually. But this occasion has come to adduce evidence after 2022 when the last attesting witness has died. In 2022, the other attesting witness dies. So the occasion to adduce a subsequent evidence to prove the execution of the will starts from 22. So we will have a look to what 22 after 22 what the plaintiff has done. You just show me whether any witness was actually produced on behalf of the plaintiff.
After
22, because that is the last date when the attesting witness dies.
PW3, he was produced in 23. Then the date was fixed on 11/7/23.
Where?
At page 9, the entire details is there.
On Delhi.
On 18/5/2023, PW3 was provided as a witness for deposition.
Okay, PW3. Who is 1 and 2?
One was the executor himself. 2 was the son of the first attesting witness to die. And 4 was also produced on 11/7/2023. The 4th witness was produced. So it is progressing, but we need some more time.
After 22, PW3 is there. 3 has been concluded.
3 has been concluded, 4 has been concluded. We need to lead certain further evidence.
Okay.
Because of the peculiar circumstances of the case.
দাঁড়ান একটু দেখে নি
let me know an opportunity being given, maybe in a time bound manner, so that further evidences could be laid. We do not want to procrastinate the case, but the facts are very clear.
The impugned order, page.
Page 40, 40.
This evidence was going on before the district judge. Now this has been transferred to the NDPS.
After NDPS. For expedition.
The defense witness has started. No.
Defense witness lots, it was scheduled to start lots. I need to. The case was fixed for defense evidence on 8th of November 2024. When it was transferred to the other court.
8 November.
No, the defense witness hasn't started yet.
Hasn't started.
Hasn't.
We start with Anukul Seal.
March.
How many witnesses are there after Anukul Seal?
Because till date we have deposed 4 witnesses. We intend to depose 2 more. Because none of the attesting witnesses are alive. So this Anukul Shilminos happens to be the son of the first attesting witness. Now I need to have a near relative of the second attesting witness who has also died.
So Anukul and plus 1.
Anukul has already deposed. Not I need 2 more.
No, deposition of Anukul is not complete. Because you come to page 9 at the end, it starts with on 14/5/2024. You have filed your examination in chief. And by mutual consent, the matter was deferred on 25/6.
Anukul is actually.
Yes.
I will give 1 more.
Affidavit of service filed on behalf of the petitioner. Service complete.
Service is complete because none of yours further respond.
All the respondents.
All the respondent service is complete.